Hi, in this video, we are going to discuss about some of the important case laws and their relevance with respect to GST. So, the first case is Wasu Clothing Private Limited versus Union of India. What was discussed here was GST leviable on supply of goods and services to duty-free shops at international airports in India. So the facts of the case. The petitioner is a manufacturer and exporter of garments in India, and he intends to supply goods to duty-free operator who in turn is selling the goods from duty-free shops. Petitioner seeks indulgence of the High Court for a grant of relief from payment of goods and service tax by way of exemption and on the goods and service supplied to duty-free shops at the international airports in India. So the petitioner's contention is that after enactment of CGST Act of 2017 and the rules framed thereunder, the petitioner is entitled to supply goods and service to duty-free shops without payment of taxes, and similar supplies from all over the world except India are permitted without the payment of taxes. So the Honorable High Court held as under for the purpose of CG. So what this is what the Honorable High Court held, that is for the purpose of CGST Act, India extends up to the exclusive economic zone up to 200 nautical miles from baseline. The location of duty-free shops (DFS), whether within customs frontier or beyond, shall be within India as long as it is not beyond exclusive economic zone, that is up to 200 nautical miles from baseline. Therefore, duty-free shops cannot be said to be located outside India. Instead, the duty-free shops is located within India. As a supply to a DFS, that is duty-free shop, by an Indian supplier is not to a place outside India. Therefore, such supplies do not qualify as export of goods under GST. Consequently, such supplies cannot be made without payment of duty by furnishing a bond or letter of undertaking under the Rule 96A of GST Rules 2017. Also, the petitioner cannot claim refund of unutilized input tax credit, that is ITC, under Section 54 of CGST Act 2017. So the High Court held it is true that we cannot export our taxes, but the fact remains that it is not the petitioner who is exporting the goods or taking goods out of India. Petitioner is liable to pay GST on supply of indigenous goods to duty-free shops. The court also held that a statute is an edict of legislature and the courts do not have the power to enact a statute, and the court can only do interpretation of statute, and once the court does not have power to legislate, the question of granting exemption in the absence of any statutory provision to the petitioner under GST Act does not arise. So that was discussed in Wasu Clothing Private Limited versus Union of India. Now, Patran Steel Rolling Mill versus Assistant Commissioner of Sales Tax. That is Patran Steel Rolling Mill versus Assistant Commissioner of Sales Tax. Here, what was discussed was satisfaction to be recorded before passing order of attachment of assets under GST. So the facts of the case. The SSC company is engaged in manufacturing and supplying of TMT bars and paid GST on the same. The revenue visited the SSC's factory and compared stock of raw material and finished good with the recorded quantity of the same. Investigation at the end of the transporters revealed that the SSC supplied and received goods without the payment of tax. The SSC was also compelled to give post-dated check towards payment. Later, the revenue passed an order of attachment against the stock found to be in excess. Several bank accounts operated by the SSC and its executives were also attached. The SSC claimed that the attachment of the bank accounts had crippled the day-to-day activities of the SSC and was impeding upon its liability to pay taxes. Hence the present writ. Now, here High Court judgment. As per mandate of Section 83 Subclause 1 of the CGST Act, the Commissioner must record written reasons before attaching any property or bank accounts or taking any such drastic action. Besides, the Commissioner must record satisfaction that such action was justified so as to protect the revenue's interest. In the present case, the Commissioner recorded no such satisfaction. Hence, no opinion could be formed to validate the provisional attachment of the property. Hence, the attachment order is unsustainable. Besides, the sum already deposited by the assessee need not be construed as admission of dues on its part. Before exercising power under Section 83 of CGST Act, the revenue must balance the interest of the revenue with those of the assessee so as to ensure that while the revenue's interests are safeguarded, the functioning of the assessee does not get crippled. Now, drastic actions under Section 83 of the Act is justified if the assessee is a fly-by-night operator or habitual offender, which is not the case here. Thus, the powers under the provision must be exercised after due application of mind. Hence, the attachment of the bank account is directed to be lifted. So that is with respect to Patran Steel Rolling Mill versus Assistant Commissioner of Sales Tax. The next case we have is NVK Muhammad Sultan Router and Sons versus Union of India. NVK Muhammad Sultan Router and Sons versus Union of India. Here what was discussed was the process of detention cannot be resorted to when dispute is bona fide. So towards the fact of the case, the first petitioner consigned a lot of Roja betel nut to the second petitioner at Kerala. It entrusted the consignment to the ABT parcel service for transportation. In the invoice, the first petitioner described the commodity with HSN 0802, HSN 0802 and paid the tax at 5%. The first petitioner also raised the e-way bill on 26/9/2018, the Assistant State Tax Officer intercepted the lorry when it reached Palakkad. The lorry had been carrying other goods too. The Assistant State Tax Officer detained the goods, alleging that the first petitioner's product fits the description HSN 2106 and attracts 18% of tax and not 5%. In other words, the Assistant State Tax Officer detained the goods because the petitioner had alleged been trying to evade the tax by misdescribing the product. So what the High Court judgment here was, the Honorable High Court held that if the records he seizes truly reflect the transaction and the assessee's explanation accords with his past conduct, for example, the returns he has filed earlier, the detention is not the answer. At best, the inspecting authority can alert the assessing authority to initiate the proceedings for assessment of any alleged sale at which the petitioner will have all his opportunity to put forward his pleas on law and on fact. The process of detention of the goods cannot be resorted to when the dispute is bona fide, especially concerning the exigibility of tax and more particularly the rate of that tax. The High Court, while deciding as above, relied on the case of JK Synthetics Limited versus Commercial Tax Officer. JK Synthetics Limited versus Commercial Tax Officer 1994. The order of detention was held arbitrary and unsustainable and was accordingly set aside. So that was in NVK Muhammad Sultan Router and Sons versus Union of India. Now, Quin Motor Company versus Assistant Sales Tax Officer. Here what was discussed was non-generation of e-way bills which invoke the applicability of section 129 of GST. So facts of the case. A person from Trivandrum goes to Pondicherry, purchases a car and entrusts it to a car dealer to transport it to Trivandrum. On the way in Kerala, the officials under GST Act intercepted the vehicle and detained the goods for no e-way bill accompanied with the consignment. After responding to the statutory notice and after suffering a penalty order under Section 129 of GST Act, both the dealer and the purchaser filed this writ petition. Should the transport at the behest of an individual and under unregistered person suffer the same statutory limitations as does the transport by a registered person or transporter? Does the second proviso to sub rule 3 of rule 138 of Kerala state GST rules save the transaction, and can we treat the car sought to be transported without an e-way bill as an item of used personal and household effect? So the judgment here by the High Court was law at times can be harsh and the courts usually defer to the legislative wisdom if the conditions under the CGST Act and rules are not complied with. Definitely Section 129 operates and confiscation would be attracted. Respondents are entitled to adjudication, but they would have to prove the goods being transported stand exempted from the rigors of GST regime. Either of the petitioners can get the goods released by complying with the Section 129 and the relevant rules and seek an early adjudication of the dispute. The High Court, while delivering the above judgment, followed the precedent laid down by the Kerala High Court in the case of Indus Towers reported in 2018. So either of the petitioners can get the goods released by complying with Section 129 and the relevant rules and seek an early adjudication of the dispute. And the High Court of Kerala relied on a precedent by Kerala High Court, that is Indus Towers reported in 2018. Saji SV versus Commissioner, State Tax Department. Payment of tax under wrong head was considered here. Now, facts of the case. Petitioner, a registered dealer, had purchased goods from Chennai. While transporting the goods to Kerala, the same were detained while in transit by the Assistant State Tax Officer. Based on the demand made, the consignor paid tax and penalty, but the remittance was made under the head of SGST. Since the remittance should have been made under the head of IGST, the authorities refused to release the goods. Hence, this petition came to be filed. Now, judgment of the court. Decision of the High Court. Section 77 of the CGST Act 2017 provides for the refund of the tax paid mistakenly under one head instead of another. However, Rule 4 of the CGST refund rules speaks of adjustment, where the amount of refund is completely adjusted against any outstanding demand under the Act. An order giving details of the adjustment is to be issued in Part A of Form GST RFD 07. Under these circumstances, High Court does not find any difficulty for the respondent officials to allow the petitioner's request and get the amount transferred from the head of SGST to IGST. It is inequitable for authorities to let the petitioner suffer on the count that such transfer may take some time. Second respondent was directed to release the goods forthwith along with the vehicle and then ensure that the tax and penalty which already stood remitted under SGST is transferred to the head IGST, and this petition was disposed of. So that was in Saji S versus Commissioner State Tax Department. And the next case we already discussed in case of Quin Motor Company and Aston Sales Tax. The Kerala High Court decision took a decision based on the Kerala High Court decision rendered on 2018 with respect to Indus Towers Limited. So, Indus Towers Limited versus the Assistant State Tax Officer. Indus Towers Limited versus Assistant State Tax Officer. Now, what was discussed here was goods cannot be detained for mere non-compliance of GST rules when the transaction is non-taxable supply. So here, the Kerala High Court held that the power of detention contemplated under Section 129 of GST Act can be exercised only in respect of goods which are liable to be confiscated under Section 130 of the Act. While allowing the petition, Justice P.B. Suresh Kumar clarified that goods cannot be detained merely for infraction of Rule 138 subclause 2 of the state SGST rules when there is no taxable supply when goods are transported on delivery challan so long as the authenticity of the delivery challan is not doubted. Now, and the petitioner company engaged in the establishment and maintenance of towers for telecom service providers transported batteries under the strength of the tax invoice. However, the department officials denied the vehicle by invoking Section 129 of the Act, finding that petitioner has not fulfilled the requirements of Rule 55 and Rule 138 of the state GST rules. The council appeared on behalf of the assessee, contended that the non-submission of KER1 was the only defect pointed out by the revenue and the same had been furnished subsequently on the receipt of the notice. On behalf of the revenue, it was contended that as per section 129, the goods can be detained for violation of CGST, SGST acts and rules, and therefore goods can be detained even in transactions which do not involve taxable supply. So, after analyzing the provision of Section 7 of the Act, the court found that when a taxable person transports the goods procured by them for own use to the site where the goods are to be consumed, the transaction would not involve any consideration. Such transaction would fall within the ambit of Schedule 1 and would not fall within the scope of taxable supply. The court noted that the revenue has not suspected the genuineness of the delivery challan issued by the petitioner at the time of transportation. Considering the question whether the detention of goods under the present case was justified on the ground of non-compliance of Rule 55 and Rule 138 of SGST Act, the court answered in negative, allowing the petitioner, the bench relying on the FAQ by the Central Board of Excise and Customs (CBEC), Central Board of Excise and Customs, released on 31 March 2017, observed that a combined reading of Section 129 and Section 130 would indicate that the goods can be detained only when it is suspected that the goods are liable to confiscation. Further, according to Section 130, the goods can be confiscated when a taxable supply is made and there is a violation of procedure with the intention to evade the payment of tax. If that be so, mere infraction of the procedural rule like Rules 55 and Rule 138 of the state GST rules cannot result in detention of goods, though they may result in imposition of penalty. In other words, detention of goods merely for infraction of the procedural rule in the transaction which do not amount to taxable supply is without justification or jurisdiction. So that was held in Indas Towers Limited versus the Assistant State Tax Officer. Now the next we have is Proactive Plus Private Limited versus State of Uttar Pradesh and others. And what was discussed here is the order passed for seizure of goods under UP GST Act 2017 instead of IGST Act 2017 during the interstate movement of such goods is impugned. Now towards the facts of the case, the petitioner preferred this petition before the Honorable High Court in order to seek directions for releasing the seized goods by respondent department under Section 129 of CGST or SGST Act 2017. Now, the disputes involved a point of dispute whether the seizure of goods under Section 129 of the UP GST Act 2017 during interstate movement of such goods is proper in the absence of provisions of eBay bill. Now, the argument of the supplier was A. With respect to supplies of goods and service made within UP, the provisions of UP GST Act 2017 shall be applicable while for all the interstate supplies, the provisions of IGST Act 2017 shall be applicable. And the second argument was the said goods were transported from another state to UP. Thus, seizure of goods under Section 129 of UP GST Act is not sustainable as the seizure can only be done under Section 129 of IGST Act 2017. So, these were the two arguments of the supplier. Now, revenue contention. Merely on the ground that wrong provision has been mentioned in the order, the said order cannot be considered as invalid. So here the legal principles were discussed. That is the first one. Section 129 of UP GST and CGST Act 2017 provides for the detention or seizure of goods in transit along with conveyance and documents in a case of a person transport any goods or stores such goods in contravention of provisions of the GST Act 2017 or rules thereunder, and can be only released after the payment of the tax amount and penalty prescribed. However, no such tax, interest, and penalty can be imposed without issuing a notice and providing an opportunity of being heard to the concerned person. Further proceeding can be initiated in the case of failure of payment of amount. And now the second one, Section 20 of IGST Act 2017 provides that provisions of CGST Act 2017 shall apply mutandis of IGST Act 2017 in the case of specified areas. Now, based on these, the judgment of the court was the Honorable High Court directed to release the goods along with vehicles seized due to the perishable nature of goods, subject to the petitioner furnishing indemnity bond and security, that is other than the cash and the bank guarantee, in respect of the proposed tax and penalty on the value of the goods as disclosed in the documents accompanying the vehicle. In case of detention and seizure of the goods or conveyances, the adjudication of the tax, interest, and penalty payable thereon should be completed expeditiously, that is, as soon as possible and in proper way. So that was discussed in Proactive Plus Private Limited versus State of Uttar Pradesh and others. Now, Samaj Parivartana Samudaya versus and others versus State of Karnataka. So what was discussed here is lessee should collect GST on sale value of mineral purchased in e-auction and can claim it in income tax credit. So an amicus curiae filed by Samaj Parivartana Samudaya and others, the Supreme Court of India directed that the buyer of the mineral purchased in the e-auction shall pay goods and service tax on the sale value directly to the lessee, who is responsible for all the compliances under the Central Goods and Service Tax 2017. The Apex Court, while delivering the first verdict on the new Goods and Service Tax law, directed the monitoring committee to take necessary action to enable the lessee to claim and obtain input tax credit under CGST Act 2017. A bench comprising Justice Ranjan Gogoi, Abhay Manohar Sapre and Naveen Sinha observed that we specifically direct the GST payable on the sale value of the mineral purchased in the e-auction shall be paid by the buyer directly to the lessee, and the lessee would be responsible for all compliances as may be required under the Act. We further direct the monitoring committee to prepare appropriate pro forma and also to take steps for carrying proper tax identification number of the respective lesses on the invoice as may be required. So that was held in Samaj Parivartana Samudaya and others versus State of Karnataka. And further we have some more case laws. That is Metro Institute of Medical Sciences Private Limited versus State of UP. Here, incorrect migration of registration or any other error or mistake therein to be rectified by the department as it is responsible for migration data correctly from the pre-GST regime to GST regime. That was discussed here. And then in Bhumika Enterprises versus State of UP, it was decided that digital copy of e-way bill is sufficient for the transportation under GST. Now we have JSW Energy versus Union of India, where it was held that high courts cannot go into the merits of the decision given by the appellate authority or advance ruling. Then we have AAP and Company versus Union of India, where challenge imposition of late fees for late filing of GSTR 3B under Section 47 of CGST Act was challenged. And here we have one more case with respect to AAP and Company, where it was held that GSTR 3B is not a return. So that is with the important case laws with respect to GST. So I hope this was helpful. If anyone wants to know in detail of the case laws that I didn't discuss, get into the facts, please drop a comment so that I can complete it. So if there is any other important case laws you want a summary on, please drop a message. And thank you all for listening to this. And so like, comment, and subscribe. I hope this is helpful for everyone. So please do like, subscribe, and comment so that I can understand and that it is helpful for you and I can continue doing this. So also hit the bell icon. Thank you. Have a nice day. Bye.